N.K. Premachandran.
Thank you very much, sir. So yesterday I have already moved the statutory resolution seeking the disapproval of the ordinance. Sir, at the same time when I moved the statutory resolution disapproving the Fugitive Economic Offenders Ordinance, I fully support the contents of the bill. And I am with the government regarding this because stringent punitive action has to be taken against the economic offenders who are fleeing after looting and fleeing the country. Definitely stringent action has to be taken. Therefore, I fully support. But my formal objection is regarding the ordinance route of legislation. Sir, it is a well-established principle, and several times I myself have stated in this house that under Article 123, an ordinance can be promulgated only under extraordinary situations as per Article 123 of the Constitution of India. And what is an ordinance legislation? It is an independent legislation brought out by the executive, not by the legislature. And further, even Article 123 does not permit the replacement of an ordinance. An ordinance cannot be replaced by a bill. That is Article 123. There is no such provision in Article 123. And also, sir, I would like to say the Constitution does not permit either His Excellency, the President or the Governor as the parallel authority to make law independent of the legislature. Here what is happening during the recess period, during the 3.5 months, 6 ordinances were promulgated by the government. My point is very well the government could have had the opportunity to pass all those bills during the last session, but unfortunately the entire session was washed out, which I have mentioned yesterday. See, if regarding this bill also, kindly see, sir, this is a new law to confiscate the assets of the fugitive economic offenders, and this is an assurance which was given during the budget speech of the Honorable Finance Minister during 2017-18. And this bill was approved on 1st March 2018 by the Union Cabinet. And on 12th March 2018, the bill was introduced in Lok Sabha. And what has happened? The budget session was there till 6th of April. See, if the government had a very good bona fide intention to get it passed, definitely the government could have resolved the impasse which was prevailing in the parliament, which was in the Lok Sabha Logjam. It could be very well resolved, and they could very well initiate the bill in the house. Instead of initiating the bill or introducing for consideration and passing of the bill, they are accepting or they are selecting the ordinance route of legislation. That is a basic objection which I would like to make in this. And on 21st of April 2018, the President, His Excellency, the President has promulgated the ordinance. So my point is, instead of getting it passed in the house, directly going to the ordinance route, it is not good for a healthy democracy. It is not good for a parliamentary democracy system in our country. Therefore, I am placing my strong objection in approving the ordinance as such. That is regarding the ordinance. Sir, coming to the bill also, both discussion is going together since both items are taken together. Sir, I support the bill. The Fugitive Economic Offenders Bill is based on the principle the non-conviction based asset confiscation for corruption related cases. Sir, this above principle is enabled under the provisions of the UN Convention Against Corruption, and which was ratified by the Government of India in the year 2011. So I fully accept the principle, and this is a new law to confiscate the assets of the absconders till they are submitted to the jurisdiction of Indian courts. So it is a stringent provision as far as the absconders are concerned. If they are not subjected to the criminal proceedings or actions before a court of law or in any appropriate legal forum in the country, if they are evading, definitely this action, it will be useful and it will be fruitful. So there are a lot of instances by which economic offenders fleeing the jurisdiction of Indian courts. There are the 2 instances. One, anticipating that there is a commencement of a criminal proceeding against him. And second one is whether when the pending of a criminal proceedings. These are the 2 instances by which getting the information or anticipation of a criminal proceeding against him, and during the pendency of a legal proceedings or a criminal proceeding, they are absconding the country after looting the banks or after looting the exchequer of the company. They are absconding. Sir, here who is a fugitive offender? Who is a fugitive economic offender is well defined in the bill, in the proposed bill. A person against whom a warrant is issued by any of the courts in India, number 1, and he left India and refuses to return to India so as to subject to or submitted to the criminal proceedings or the Indian judicial proceedings he is being declared, he will be declared by a deputy director or by the special court as a fugitive economic offender. I fully agree with it. See, here the point is, if such a person has been declared as a fugitive economic offender, even before the conviction, his property, his assets can be confiscated. That is the biggest provision which we are dealing with. Sir, here the first point which I would like to make, and I am seeking a very specific clarification from the Honorable Finance Minister who is in charge of the Finance Ministry. Sir, it's a very, very important question which I would like to make. If the government is sincere, suppose if the government is sincere in confiscating the assets and containing or getting these offenders back to India, whether these provisions will survive the legal scrutiny, that has to be examined in detail. Otherwise, I will say that this is absolutely a whitewash, because all these persons have left the country. I'm not going to detail all these things. These economic offenders, they have found out their heavens in US and UK and various countries. Lalit Modi, Nirav Modi, Vijay Mallya, all these persons have fled the country. And after all these persons have left the country and they have found their own heavens in outside India, now we are coming with a legislation to deal with that subject. And when we deal with the subject, definitely once again I want to repeat, and I assure we fully support, but at the same time, whether this is a sincere effort on the part of the government to deal the subject, I apprehend. I make my apprehensions. Why I am saying, sir, there are a lot of legislations in our country regarding the economic offences. We are having the Prevention of Money Laundering Act, we are having the SURFACE Act, and we are having the Insolvency and Bankruptcy Code, and we are having the Negotiable Instrument Act. Sir, Deputy Speaker, sir, you may kindly see, if a check is dishonored, there is a scheduled offences there. But a number of offences has been narrated in the scheduled offence as a part of the bill, in which it is being stated that if a check is dishonored and that party, the party who has drawn the check has gone outside, now he is staying in Gulf countries, sir, his property can be well confiscated. If the value of the dishonored check is more than 100 crores, am I correct? You may clarify. See, this is the provision. Whether it is legally sustainable, that is only question. Whatever stringent provision the government takes so as to deal with this economic offenders, fugitive economic offenders, we fully support, firmly support. But at the same time, it shall not be just for the political sake or just to make the public see that we are taking stringent action against the economic offenders. And that is the point. See, why I am saying is the proposed new bill differs from the existing laws in two crucial aspects. The first one is, it allows confiscation of assets of alleged fugitive economic offender before the conviction. And second one is, another important fact I would like to draw the attention of the Honorable Minister, it disentitles the fugitive economic offender from any recourse under civil law. These are the two controversial provisions, these are the two important provisions that is going to be a legal scrutiny before a court of law. Whether the government is able to define and clarify and sustain these two controversial provisions in this act, then I fully agree with the government that the impression the intent of the government is absolutely in a fair manner. So these are the two distinct features of this bill. So here I am seeking clarification. See, why I am saying is, the recent judgment, July 2016, there is a Supreme Court judgment. And that judgment is a Constitution bench judgment also, in which the Constitution bench, access to justice is a facet of right to life guaranteed under Article 21 of the Constitution. Access to justice is a fundamental right which will come within the purview of Article 21, that the right to life. So it is the most important cardinal fundamental right available to the citizen of a country, access to justice. But as per the provisions of this law, recourse to the civil law, suppose even the property is confiscated before anybody is having any interest over the property, or any claim is there over the property, nobody can have a recourse in any court of law, in a civil court of law, so as to make his claim. That is a controversial provision. And 2 points I would like to make. One is, in the judgment also it is being specifically stated, no individual can be penalized without being convicted. Here, sir, you may kindly see, even a suspected offender, Suppose a person is suspected that he is going to flee the country, his property can, I am fully supporting it. The only question again and again I am reiterating whether legally sustainable, that has to be looked into by the government.
Right.
Sir, please, sir, this is, I am only initiating this. Sir, and the second one is no one can be denied access to justice. That is the second point. Sir, if it is a well-established legal specific, whether the government is confident that the bill will pass the judicial scrutiny. And sir, it is also the legal dictum that unless and until a person is being accused is proved to be guilty, he is presumed to be innocent. That is a basic legal dictum also. So that is the first point. And sir, regarding the second point, why these people have become fugitive, this is the second point which I would like to make. Sir, if the prevailing provisions of the existing laws are strictly complied with, how can these people become fugitives? How can they loot the country and run away from the country? Sir, Vijay Mallya, Lalit Modi, Nirav Modi, Mehul Choksey, Deepak Talwar, Sanjay Badar, J.K. Garg, R.K. Kapoor, and Pratik Jindal, all these persons, the latest SRS bank default case of 6,978 crores of rupees, all these cases, Vijay Mallya rupees 9,000 crores, because of the paucity of the time, I am not going to the details. So all these cases have happened during the last 4 years. Is it not the fault of this government? Nirav Modi, Vijay Mallya, Mehul Choksey, Deepak Talwar, all these persons fled the country, left the country during the government, during the NTA government, during the last 4 years. You have not taken caution so as to check these things. Instead of doing this, see, Nirav Modi case, or Nirav Modi, Punjab National, it is quite unfortunate to say, in the last session, that this house has not even discussed about the Nirav Modi, Punjab National Bank scam. Sir, if you kindly see, the LOI, letter of undertakings issued to Nirav Modi by the Punjab National Bank when from 2011 to 17, 150 LOUs were issued in favor of Nirav Modi. Sir, 143 LOUs were issued in 63 days from March 1st, 2017 onwards. So whether it is not with the knowledge and consent of the government. And finally, you may kindly see that the Punjab National Bank has come to the notice. Sir, I will conclude within 2 minutes. Because this Nirav Modi's case, Punjab National Bank scam, has never discussed in this house. That is why I may kindly be given 2-3 minutes. Sir, regarding this, on January 16, 2018, this has come to the knowledge of the Punjab National Bank. On 29th January 2016, a complaint was filed by the Punjab National Bank, and CBI registered a FIR on 31st January. Nirav Modi and brother left the country on January 1st. Mehul Choksey left the country on January 6th. Sir, is it not without the consent and knowledge of the concerned authorities so as to leave the country? Is it not without the knowledge? And there are so many petitions were there in the Gujarat High Court against Mehul Choksey. More than 500 petitions were submitted before the courts. And there were the CBI petition was given. A whistleblower has submitted a specific petition to the Honorable Prime Minister. And the Prime Minister has acknowledged the receipt of the petition against the Mehul Choksey. What action did the government take? Instead of taking any action, finally you are coming with the legislation. We are going to confiscate the property of all the economic offenders. Whether we can believe the earnest efforts or the bona fides of the government. Sir, instead of going to the continuous legislation, the government should have the political will to enforce the laws against the corporates. You are losing the political will to deal the corporates. That is the biggest problem is the country is facing. So, sir, my submission is, from this, it is very clear that the government of India was fully aware of the possible devastating outcome of the fraudulent scams, and the government cannot evade from its responsibility. So, sir, since all these scams are of grave importance and members representing the highest office of our democracy could possibly be involved, I demand a joint parliamentary committee to probe into this matter to bring out the truth in the public domain of all these issues. Sir, the last point, sir, 1 second, very, very important point, sir. After all these scams, now FICCI and ASOCHAM, all these corporate organizations are coming that all these scams have happened only because of the public sector banks. So all these public sector banks have to be private. Sir, I'm concluding. Just 1 second. All these private sector banks have to be privatized. That is the new philosophy which is being brought by the corporate houses. Sir, is it because of the public sector banks? It is only because of the political influence by which all these corporates have looted the country and fled the country. So my submission, my suggestion is, if this government is earnest efforts or it is bona fide in containing or bringing back all these things, this legal clarification has to be made.
Okay.
And if it possible, there are three or more, four precedents in this house that a bill, even though it is replacing an ordinance, those bills have been sent to the select committee and joint committee. That precedent is there. So my submission is, let this bill be sent to a standing committee, finance standing committee, so as to have a close scrutiny, even the legal scrutiny, so that all these loopholes of the loopholes can be cut. With these words, once again, I move the resolution disapproving the ordinance. I support the bill. With these words, I conclude. Thank you very much, sir.